Welcome to the House Committee on Judiciary, Tuesday, March 5th, 2019. We have one bill on our agenda for consideration, and we have we have 14 bills to hear. Can I hear a motion to hold all of the bills scheduled for hearing and/or consideration, hold all bills for further study?
So moved.
All those in favor signify by saying aye.
Aye.
Opposed, nay. The ayes have it. As to the one bill that is here for consideration only, can I have a motion to hold House Bill 5125 indefinitely and deal with and vote out House 5125 Substitute A?
So moved, Chairman, to permanently hold 5125 and substitute it with 5125 Sub A.
Second.
All those in favor signify by saying aye.
Aye.
Aye. Opposed, nay.
Nay.
I'm sorry, Chairman. Is this the vote on Sub A, or is this the vote?
This is just
to adopt it, to put the Sub A in play?
Correct.
Okay.
So now
I
we're
vote nay.
we're dealing with House Bill. The names, oh yeah.
Clarify what the question was.
This vote was to permanently hold the original bill and to postpone it.
Postpone.
We're holding it. And then the Sub A is the bill we will debate and vote on tonight.
Mr. Chair, this is just proceed.
It is.
So the nays are Representative Place, Representative Roberts,
Yes.
Filippi.
and Filippi.
Okay, now we're dealing with 5125 Substitute A, sponsored by Representative or Chairman Williams. Do I have a motion to adopt?
Motion to pass?
Second.
Second?
Discussion?
All right, it's now in play, so any discussion would be appropriate. I'll be happy to call on anyone. Yes, Representative Place.
Mr. Chair, earlier in the evening, I submitted a couple of questions just for clarification to the legal counsel. May I be permitted to ask those questions at this time?
Sure. Which legal counsel did you address it to?
I passed on, the staff passed it on to him, so I'm not sure exactly who had received it.
Go ahead.
Thank you. John Manny for House Judiciary.
This is just with reference, John, the questions that Representative Place asked you. That's all.
Yes. There were a couple of questions. One of the questions dealt with the term on page 1, line 11 and 12, interference with an individual person's decision, and the term interference and the definition of that as compared to the term restriction. According to Black's Law Dictionary, the 10th edition, the term interference is defined as an act of meddling in another's affairs, an obstruction or a hindrance. Whereas restriction, the term restrict means a limitation or qualification relative to that. So basically that's the difference. You had a question relative to page 1, lines 13 and 14, how the term health is defined and whether that may or may not include mental health. That term health in the statute is not specifically defined. However, according to Black's Law Dictionary, the 10th edition, that deals with the quality, state, or condition of being sound or whole in body, mind, or soul, the relative status of one's physical or mental well-being. I think the key language in that section that you dealt with has to be the term necessary, though. It's got to be medically necessary or to preserve the health or life of that individual, which is determined by a physician. And they would use the common use of that term health, which may include either or. There was also, you had a question relative to page 2, lines 24 through 26. The termination of an individual's pregnancy after fetal viability is expressly prohibited except when necessary in the medical judgment of the physician to preserve the life or health of that individual. You wanted to know if that conflicted with language on page 1, lines 11 and 12, which prohibited interfering with individuals' person's decision to continue the pregnancy after fetal viability. I don't see them in conflict. However, the second portion, except when medically necessary, or when necessary in the medical judgment of the physician, that's an exception to page 1, lines 11 and 12. So that's merely an exception, and that's it.
Okay, thank you.
I'd like to take the opportunity to address some of my own comments about things that I've been told from constituents, from my own review of the Sub-A, in hopes that at least my interpretation of what this bill means or doesn't mean, probably more importantly, will begin this discussion and this debate. This is a strict codification of Roe versus Wade, which has been federal law adopted by the United States Supreme Court in 1973. There have been several statutes over the years that the Rhode Island General Assembly has made attempts to deal with abortion in statute, which have been, in my opinion, unsuccessful, unenforceable, and most importantly, unconstitutional. This bill is what I believe to be a true representation of what the United States Supreme Court meant in Roe versus Wade. Specifically, that it is that Roe versus Wade and this statute deals with science and the science of viability, and not the religious issues, the moral issues. It was the intent of the Supreme Court in deciding Roe versus Wade to deal with viability in the context of science. Viability meaning, when does a fetus acquire a status where it becomes a life? The first trimester, Roe versus Wade tells us that a woman's choice is hers and hers alone in reference to getting an abortion. In the second trimester, there are some restrictions. And of course, we've all heard about some of these statutes that Rhode Island has passed and other states have passed, which talk about late-term abortions and the like. I believe my reading of this as both a lawyer and a legislator is that the ability to get a late-term abortion, that which is most offensive, I believe, to the Catholics that live in my district, and in some instances are members of my family, it will be much harder to accomplish such a goal of a late-term abortion if this bill passed than under existing law as we sit here today. That's my opinion. So this bill will expressly ban and prohibits all late-term abortions except when necessary. And that word is going to be probably, in my opinion, the most important word we're going to hear tonight. Necessary. For the life or health of a mother. That's not a necessarily subjective decision by a doctor. It is, in my opinion, an objective decision by a doctor based on medical science and based on the fact that if that doctor does not treat the patient, the woman, in the course of making that decision to abort a child, within the standard of care that obstetricians and whoever else would be performing these abortions would be subject to civil and criminal penalties for doing so. It also adds new language confirming the federal statute which bans partial birth abortions and affirms that partial birth abortions will remain banned under Rhode Island law. And it repeals all previously passed by the General Assembly statutes that relate to abortion, directly or indirectly, as being unconstitutional. I'd be happy to answer any questions, or I'll open it up to members of the committee to debate the issue.
Just one point of clarification,
Sure.
Mr. Chairman. Maybe legal counsel can answer this. Are there criminal penalties if we were to pass this bill if someone performs a third trimester abortion in violation of the law? Or are those just subject to professional discipline for unprofessional conduct?
It's the latter, and
So just the civil unprofessional conduct
it isn't just, because it also includes criminal penalties.
for unprofessional conduct?
Correct.
And who decides that? Is that judicial or is that in the Department of Health?
Would be the jurisdiction of the Department of Attorney General or the department, the medical director of the doctors referring it to the Attorney General's office.
For unprofessional conduct?
It's Board of Medical Licensure, according to what Dan just told me.
Okay.
Yep. Okay, any more? Dr. Covesi?
I would like to make a few comments, Mr. Chairman.
Sure.
Mr. Chairman, members of the House Judiciary Committee, and with all due respect to the bill's sponsor, Chairwoman Williams, who is a dear friend, and the other 4 co-sponsors, all of whom have my respect, it is my firm belief that, contrary to reports about this bill, House 5125 Sub A is not a strict codification of Roe v. Wade, with all due respect. For that reason, and several others not necessary to delve into at this time, I'll be voting no on this bill and urging the members of this committee to vote no passage this evening. I will not belabor this committee with an in-depth legal dissection of this bill this evening. I will, however, briefly point to the inadequacies of this bill that make it the very opposite of a strict codification of Roe v. Wade and its legal progeny. This bill, in its current form, repeals statutes prohibiting partial birth abortion without replacing it with constitutional language modeled after the U.S. Supreme Court's decision in Gonzalez versus Carhart to ban such procedures and maintain a status quo. Potentially prevents, through broad language, state government agencies such as the Rhode Island Department of Health from regulating abortion clinics, and potentially prevent state agencies from adopting and enforcing meaningful rules and regulations for abortion providers. It does not expressly restrict state funding of abortion, provides no penalties for violation of the prohibition on fetal experimentation, does not provide a definitive definition of health of the individual as it relates to the exemption on the prohibition of post-viability abortions, leaving that wide open to legal interpretation. Repeals the important and necessary language that would classify as manslaughter the willful killing of an unborn quick child, defined in terms of viability, by any injury to the mother of the child, which would be murder if it resulted in the death of the mother. And for that, I can point to the sad case of Jennifer Irigoyen in Queens, New York. For these reasons, and the unwavering firm belief that this is not a strict codification of Roe v. Wade, I most respectfully request my colleagues on the House Judiciary Committee to vote no on House 5125 Sub A. Thank you, Mr. Chairman and members of the committee.
Thank you, Dr. Covesi. Blake?
Thank you,
Oh,
Mr.
leader.
Chairman.
Leader, I'm sorry.
I appreciate that, Bob, Chairman. I think we have an issue we need to deal with. I've looked up the sanctions for unprofessional conduct, and there's nothing about criminal charges in the sanctions for unprofessional conduct. You can get fined, you can get your license revoked, and I'm referring specifically to 537-6.3. There's nothing in there about criminal charges. So I would have to say, Mr. Chairman, that if this committee thinks that someone who violates the provisions preventing late-term abortions, if someone on this committee at this moment thinks that there are criminal penalties under this bill, you're mistaken unless someone can produce and show me a statute that has criminal penalties for unprofessional conduct. I mean, is that possible that we can hold on for a few minutes and someone can produce that statute?
We'll hang on a minute, but in my opinion, the Department of Attorney General has plenary jurisdiction over whether or not someone blatantly violates someone's rights and does something contrary to state law.
So if I read what we're passing, it says that any physician who knowingly violates provisions of this subsection, and that's the one dealing,
Correct.
what we're dealing with today, that concerns late-term abortion, shall be deemed to have engaged in unprofessional conduct for the purposes of 537-5.1. And then after that, we strike out all the criminal penalties. So it seems to me the only penalty a doctor who violates the law would be facing is unprofessional conduct. Now, if there were criminal penalties associated with unprofessional conduct, I'd like to see it because I'm looking at the statute right now and there's nothing in here about
If I could draw your
criminal
attention,
conduct.
Leader, to Section 5-37-25 point, and it says violation penalties.
Yeah.
Do you have that?
5 dash, what is it?
5-37-25.
Yeah.
It's entitled Violations/Penalties. And it specifically says, in reference to the Board of Licensure and Discipline, that unless another penalty is provided by the law of this state, any person who violates any provisions of this chapter or any rule or regulation adopted under this chapter shall, upon conviction, be punished by a fine of not more than $1,000 or by imprisonment for not more than 1 year, or both.
So it's a misdemeanor.
Yes, it's still a crime.
Okay, so we're taking
Yeah, we're
it
not,
from,
this isn't a grand jury matter, but it is serious. Conviction of a criminal, of a misdemeanor by a doctor is automatic loss of license.
okay, so we've established that the penalty is a misdemeanor, it's not a felony.
Correct.
If you are a doctor who knowingly performs a third trimester abortion in violation of the state statute.
Correct.
Okay, I appreciate that. I would suggest that a misdemeanor isn't enough. I'd like to add some other comments if I could at this time,
Sure.
please. Okay, so there's a few issues I see with this bill and the notion that it strictly codifies Roe v. Wade. I think it goes beyond Roe v. Wade, Mr. Chairman. Attorney Manny a few minutes ago said that health includes mental health from Black's Law Dictionary. We don't have a definition of necessary. Suppose there's 5 things that someone could do that are necessary to preserve their health, mental health, physical health. 4 of them wouldn't involve an abortion, but 1 does involve an abortion. It seems like in that instance that someone could pick the one that involves the abortion when there would still be the ability to preserve the fetus to term. Because there's no definition of necessary and health is broad, I think it creates a very, very gray area that doctors can operate in. And the doctor who's going to be determining whether it is in compliance with the statute is the one who's performing the abortion. So I just think it sets up a moral hazard. I think it sets up a lot of gray area for someone to play around in, if you will. And when the penalties are administrative and potentially misdemeanor penalties, I just feel that when there is such a gray area, I think there needs to be stricter penalties when that gray area is violated. I think we're setting ourselves up to have violations. Next, I really want to go into fetal homicide because this is something which I think is really problematic. If you remember, during the committee, we had a colloquy with, I think it was Attorney Labinger from the Attorney General's office, and essentially they said that the reason they want to get rid of fetal homicide is because they want to deny legal status. They want to deny personhood to fetuses. I see nothing in Roe v. Wade that protects the ability of a third party to instigate an unwanted abortion and take away a woman's reproductive health. If we pass this law, an upset boyfriend at 8.5 months pregnancy could throw his pregnant 8.5-month girlfriend on the ground and stomp on her stomach with the intent of killing the fetus. The fetus could die, and the charge which we're left with is a simple assault charge. We're eliminating homicide on the fetus. We're eliminating manslaughter on the fetus, which we have in law now. I don't know why would we be doing that. There's no right in Roe v. Wade to terminate someone else's pregnancy without their consent. This goes so far beyond Roe v. Wade. I just don't understand why we would be eliminating fetal homicide. If there's a problem with the statute, as Attorney Labinger had said, let's fix it. Let's take out the doctor. Let's take out the pregnant mother and just have fetal homicide for a third party who terminates someone's reproductive choice. They're taking away someone's reproductive choice. We need to protect women who are victims of criminal action. I can't understand why we'd be taking that out. I just don't understand it.
Well, if I can address your issue.
Please,
First,
please,
one point for clarification. In reference to the statute I talked about, the misdemeanor statute, it isn't specifically, that statute doesn't specifically apply to only a physician performing an abortion illegally. It applies to anything where the doctor specifically says that, does something that violates the tenets of that statute, Title V.
Are you talking about the fetal homicide line?
No,
of
I'm
question?
talking about earlier when you said, what is the doctor going to be penalized with? There's no criminal penalties. I pointed out that there was a misdemeanor penalty, and we talked about, but it's not specific. That misdemeanor penalty is not specific to only abortion or an illegal third trimester abortion. It applies to other things that a doctor could do, as well as performing illegally a third trimester abortion. In reference to your concerns about the feticide and the issues of protecting a woman's child in uterus, 8.5 months, crazy boyfriend, etc., there are a plethora of other charges that are serious and draconian in their, not only the penalties, but the sentencing guidelines. Felony assault, permanent injury resulting is 20 years, and there are serious parole issues related to that. I would hazard to say, from my 10 years of experience as a prosecutor, I've never practiced in front of a judge who would have any sympathy for someone who committed such a crime under those circumstances as you described, that they wouldn't apply or sentence someone to the maximum that they could under the sentencing guidelines, or maybe exceed them.
And I understand, but the point is that it's because of the crime to the mother.
Yes.
We're taking away the crime against the fetus.
Correct.
So we're denying legal status to a fetus that could be 8.5 months old.
Mm-hmm.
I just think that's wrong. There's nothing in fact, Roe v. Wade said after the second trimester, the state has a compelling government interest in that fetus. So why, if we're trying to codify Roe v. Wade, are we denying legal status to the fetus? It seems like Roe v. Wade said the state has an interest in that fetus. It's the wrong move. We should not be doing it. I'll move on from that. Lastly, dealing with partial birth abortion. We are eliminating our state statute on partial birth abortion and just saying the federal partial birth abortion statute applies. But our big concern, well, many advocates' big concern, is that the federal government is going to overturn Roe v. Wade. We don't know how the federal government's going to get out of abortion. The federal government may say, or the Supreme Court may say, Roe v. Wade isn't a constitutional right, but also the federal government, under the Commerce Clause, you don't have the ability to regulate this conduct. And they could also overturn the federal partial birth abortion ban. So why would we be eliminating it in this state? If we're really trying to codify existing law, we need to incorporate all the federal law, not just the ones that people want. Because I'm concerned, and we all know what's happened to the Commerce Clause line of case law in the federal courts. They're ratcheting it back. Maybe they don't have the ability under the Commerce Clause to stop partial birth abortion, and then if that's overthrown, it would be legal in this state.
So, Leader, a partial birth abortion is a late-term abortion, correct?
It's a method of late-term abortion.
Okay. In our legislation, we are banning late-term abortions. So we have our own partial birth abortion in addition to the explicit reference to the federal partial birth abortion.
We're not banning partial birth abortion. We're not banning it. We're saying it can be done under certain circumstances.
Which is exactly what's in the federal partial birth abortion now.
I think
Life
you,
or health of the mother.
I think you and I are talking about something different. You're saying that we now are having restrictions on third trimester abortion, correct? That's what this law says. You can have a third trimester abortion under these certain instances.
The same instances as in Roe v. Wade.
Okay, correct, but we're dealing with partial birth abortion. Partial birth abortion is a method of late-term abortion.
So if we ban all late-term abortions, any method of late-term abortion is banned.
We're not banning it. We're not banning it. We're allowing it. We're allowing it except when necessary to, in the medical judgment of the physician, to preserve the life and health of that individual. So we're not banning it. We're restricting it. And the partial birth abortion is a method of late-term abortion, which I think is abhorrent. And why would we just be adopting the federal law? Why don't we just mirror the federal law and put it into our law? Why are we getting rid of it?
Because we arguably go further than the federal law by banning all late-term abortions.
Where do you get that we're banning all late-term abortions?
Lines 24 to 26 on page 2 of the legislation.
Except when necessary in the medical judgment of the physician to preserve the life or health of that individual. We're not banning all late-term abortions. They're allowed within a restricted universe. And what the partial birth abortion ban says is that within that universe, you can't use this method. We, in our state statute now, disallow that method too. But we're now excluding in state statute the ban on that method and just saying, oh, we're going to rely on the federal statute, but we don't know what's going to happen on the federal government. If we really don't know what's going to happen on the federal government, it could also go the other way. We should be incorporating that federal law into our law.
I think we're talking in circles here, but I appreciate your point.
I'm trying to be direct. I don't want to get sidetracked by talking in circles. I'm being direct. It is a method, and it is the method which we're eliminating from our state statute. And I don't want to rely on the federal government. The big fear is that this goes, south with the federal government, and they no longer are in the abortion business. They might get out the other way and say the federal government doesn't have the ability to regulate the individual conduct of the people through the federal partial birth abortion ban. Thank you.
Vice Chair McEntee.
Thank you, Mr. Chairman. And Leader Filippi, I just wanted to point out, the alternative to this line 24 through 26 on page 2 would be not to have that exception for the life of the mother. Are you suggesting that we don't preserve the life of the mother?
I'm suggesting we define necessary. I'm suggesting we define necessary and we define health. Is it physical health? Is it mental health?
To preserve the life or health of that individual.
I think we should have that, but we should attach a definition to it. Suppose there's, like I said earlier, there's 5 things that one of those is necessary.
Well, preserving the life is pretty clear, would you not? Would
I
you
agree
to that?
completely. I agree completely. But it's what is necessary?
Well,
What is the definition of necessary? What is the definition of health?
Medically necessary, health of that individual. If it's going to permanently harm the mother to deliver the child, and her life would be at stake.
I agree. If there's only one
No other
thing-
option.
No, but here's the thing. There could be other options. But what if there are 5 options and it's necessary that they pick one of those 5? Should we?
There's no other option than preserving the life of the mother.
I agree.
Okay.
But maybe a procedure that would preserve the life of the mother and preserve the life of the fetus. I just think we need definition in necessary. And we need definition in health. We heard earlier that it's mental health as well. Is that what we're doing? We're saying to preserve the mental health that we can allow a 3rd trimester abortion? Because I read the statute and I read Attorney Manny's interpretation of it, and it's mental health as well.
Well, medical doctors generally, depends on who what kind of physician you're attending. If you're going to see a psychologist, then obviously they're concerned with your mental health. But if you're going to see someone for the purpose of OBGYN and wanting to terminate a pregnancy or having health issues that could prevent your life from continuing, then I think their concern is with your medical condition, your physical condition, not your mental condition.
So then why don't we put physical condition in here and define it, define health to not be mental condition? Hey, listen, we're both attorneys and we have different interpretation. Clearly the language is not clear enough.
Dan?
I would like to comment on that very quickly. Mental health and physical health are completely interrelated, and there are many occasions where a person requires medication to stay in mental equilibrium. And those medications are not consistent with pregnancy. And so the person gets off the medication so that they can become pregnant. They are pregnant and they start having a very bad episode. In my mind, the distinction that you're making, Representative, with all due respect, I am listening very carefully to what you're saying, but health is health. And whether it's a mental illness or a physical illness, something that is going to impact the mother's health is something that should be respected by the medical care providers. That's my 2 cents. And, but thank you.
If I could read some language directly from, well, kind of the essence why we're here, Roe versus Wade. Right when the Supreme Court got to the question of viability and dealt with the first trimester, this is the language that the court used. For the stage subsequent to viability, the state, in promoting its interest in the potentiality of human life, may, if it chooses, now this is the state, regulate and even prescribe abortion except where it is necessary in appropriate medical judgment for the preservation of the life or health of the mother. We are prescribing that a third trimester abortion and even the issues relative to the health and safety and welfare of the mother versus the child, the balancing test, as I like to call it. Lawyers love to discuss that, things in this particular way. Balancing the interest. The mother is a human being. The child is a fetus. The Supreme Court of the United States of America has said it doesn't acquire viability until the third trimester, until it can live on its own. And until medical science changes to the point where, that doesn't seem to be the case anymore. And I know medical science has evolved from 1973 in reference to viability. I have a doctor who lives in my neighborhood who does prenatal brain surgery. Fascinating guy, and he talks about doing an operation on a fetus. For where it's deemed necessary. So if you can operate on a fetus, clearly it has acquired something beyond just this thumb-like picture that we see posted frequently. I believe that the Supreme Court in Roe versus Wade actually spoke to this proposed bill and potential statute that we are dealing with today. And that is what we're trying to do here. We're getting rid of unconstitutional laws that have been attempts in the past to deal with abortion. And we're either expressly eliminating an unconstitutional law and substituting it with what I believe to be a exact statute that codifies what the U.S. Supreme Court said in 1973 and the progeny cases that came thereafter. Honestly, what I think we're doing is a good thing. I think we're making it clear what can be done, but as I have seen the arguments from both sides, we're making it clear what can't be done. Late-term abortions, that there's a respect for the third trimester, that the doctors are held to the standards that are appropriate, and that they'll be punished if they don't stick to those standards. I believe that this is a good thing, and I believe that, quite frankly, the time has come for the General Assembly in the state of Rhode Island, the House in particular, and this committee specifically, to recognize those rights of a woman and to say, look, it's your body. You can make those decisions with these caveats, with these rules, with these limitations, both to doctor as well as mother. It's not a throwing out the baby with the bathwater. I don't believe so. I'm a Catholic, 12 years of Catholic education. Obviously, all of us here who've been to Catholic school, and I'm sure I'm not talking out of turn by saying we probably got emails from constituents who are parishioners in the churches that we go to. This may be a difference of opinion as to how we word it, but I'm not sure it's a difference of opinion as to whether it's right. Yes, Representative Place.
Thank you, Mr. Chairman. Representative Corvese didn't want to get into a legal argument. We've got a couple lawyers here arguing over case law and things like that. I'm not a lawyer, but I did go through and look at everything from Roe v. Wade to Casey to Gonzalez and one or two in between, Webster. And you talk about Roe v. Wade, but my understanding of Casey is, the court allowed the state to regulate abortion during the entire period before fetal viability, and they could do so for reasons other than to protect the health of the mother. The court also dismantled the prohibition on the regulation of abortion during the first trimester, part of Blackmun's, I guess they call it the tier system. They started to dismantle it in Casey, and its limitations on the regulation between the end of the first trimester and the point of fetal viability, again, getting into the second tier of the process. And the result was that the state's interest in and regulating the potential life could now arguably extend throughout the woman's pregnancy. And I think, from my standpoint, and I think what Leader Filippi is getting at is, we are addressing Roe and its progeny from the perspective of the rights of the mother, which, as an individual libertarian, I can't argue with, but at some point we get to a point where there's a second human being involved in this, in my personal opinion. Where that is, I don't know. I mean, yeah, Barack Obama said it's above his pay grade in terms of life, but I think that somewhere in there, once you get into that third trimester, we're dealing with a human being. And in my opinion, we're going away from our moral responsibility to protect the potential life, if you just want to use the strict legal definition. And again, at any point in time when I've got 3, 4, 5 lawyers sitting here arguing over the interpretation of this, that tells me we haven't done our job to actually lay out what we want it to say. And in my mind, that's the biggest fault with this legislation. It's just not ready. It's not ready to be voted on the floor right now. If folks want to codify Roe v. Wade, well, let's codify Roe v. Wade and Casey and Gonzalez, and I think we get into in Webster, and let's bring it all together and come up with something that we're not arguing over interpretation. Because if we're arguing over the interpretation, there are much smarter attorneys than are in this room that can go before a judge and argue the hell out of this and put us in a position where we may have done something we never intended to do because we just didn't tell them what we wanted to do. And in my opinion, we're just too vague. Thank you, Mr. Speaker.
Dr. Covesi.
Thank you, Mr. Chairman. As a layman, I sat here for 20 minutes and listened to 4 distinguished, well-respected lawyers discuss the definition of health, and they came up with what I came to be 3 different interpretations. So if just on that word, just on the fact that we do not have a definitive definition, will certainly make that, as I said earlier, wide open to legal interpretation. I do not think that that has been buttonholed to the point where health is uniformly understood in the language of this bill. And that's just one of the points that I feel, my personal opinion and my opinion as a state representative who's trying to do the right thing, that this bill is not a strict codification of Roe versus Wade.
Dan?
I would say respectfully that if you put any lawyers in a room on any issue, you're going to find a debate. And I mean that respectfully, because the way everyone has their commitments to things, but there was an attempt, a massive attempt involving a lot of people, some of whom are in this room, some of whom spent many hours, attempting to take all of the teachings of Roe v. Wade and all its progeny and put them into a statute. Now, it can always be argued whether they did a good enough job. In my view, this was a very wonderful job, but everyone's going to have their own opinion. The fact that there's debate does not change what it is. Anyone can debate anything. And, in this modern day of ours, we can debate whether the sky is blue. I don't want to get too far afield here. The law is the law. It has been decided by the Supreme Court. It has been in existence for over 40 years. We have had unconstitutional laws on the books. Anyone who says that they're pro-life says respect life, but you have to respect other things as well, including the U.S. Constitution. And in order for people who want to use respect as a means of changing this issue, you have to start by respecting. You have to respect women. You have to respect the United States Supreme Court. You have to respect its decisions. You have to respect the fact that there is a divided country on this issue. But the U.S. Supreme Court is empowered to define what is the rights of an individual versus the government. And that's the end of the story. We're not talking about changing the law here. We're talking about making our law constitutional, which is, in my mind, talking about taking a 40-year-old beacon that says we don't respect and turning into a beacon that says we do respect, so that the conversation can continue. And that's all I have to say on that.
Yes, Chris.
Chairman, thank you. Members of the committee, Mr. Chairman, I've sat here in silence over the last couple of weeks. I haven't voiced my opinion as a freshman. I've listened. I've listened to many bills. This bill being extensive, the amount of feedback that has come my way, be it emails, phone calls, constituents bumping into me, my fellow representatives speaking to me, different lobbyists. There is no more divisive issue that could possibly come before this committee. I totally and 100% respect every member of this committee, Chairwoman Williams, everybody that has sponsored and co-sponsored this bill. I, as most people have learned, at least this morning, am pro-life. I also have a balancing act that I need to adhere to, and I need to adhere to my constituents who put me here. I need to read the law. Now, I know everyone on this committee has read Chairwoman Williams' bill, the sub-A and the current bill. The previous bill and the sub-A. I actually spent my weekend reading Roe v. Wade, Casey versus Planned Parenthood. I've read, and I can say I've read, the federal partial birth abortion statute. I have read the Hyde Amendment, which many people in this room have not read. And I've evaluated, and I have thought about, and I have taken into consideration this bill, because I don't represent Chris Millay, myself, my wife, my family. I represent my constituents. That being said, I have received overwhelmingly emails, phone calls, whether it be today, yesterday, or throughout the month of January, February, and part of March. Constituents asking me to vote against this bill because it expands the definition of abortion. I'm listening respectfully to Leader Filippi, Representative McKeon, and Representative Shanley, Chairman Craven discuss the definitions within the statute. And again, taking it all in, listening to it. The problem I have with the current bill in its current form is the word health. I cannot lie about that. If you read the partial birth abortion section and you read the Hyde Amendment, the federal government went to great lengths to include the word physical in describing anything as it pertains to a woman after viability. God bless you. God bless you. Looking at the Hyde Amendment right now, in subsection 2 of section 303, in the case where a woman suffers from a physical disorder, comma, physical injury, comma, or physical illness, including a life-endangering physical condition caused by or arising out of the pregnancy itself, and so on and so on. I have major concerns to the definition. As Representative Corvese just indicated, we can argue about words, but when it's unambiguous, it's not constitutional. It needs to have clear meaning. Statutes need to have clear meaning. As I indicated before, I am pro-life, but I am certainly not the person to take away the choice of any female who walks this earth, whether it be my wife, my 2 children, or anybody else. That is not my position. But I will not be part of the expansion of abortion. This is extremely personal issue to every single person, either in this room, in this building, or anyone following these proceedings. If this bill is to be voted on, and if I am to vote no, nothing, I repeat, nothing changes for any female who's pregnant. The law of the land is Roe v. Wade, and any female can go out tomorrow and still exercise their constitutional rights. This doesn't change a single thing. And I want to be clear about that. But it would expand that, in my opinion. Thank you, Mr. Chairman.
Thank you. Any further questions or comments by members of the committee? Do I hear a motion to pass the Sub-A version of House Bill 5125?
Motion to pass House Bill 5125, substitute A3.
Second.
Roll call vote, please, Madam Clerk.
Craven.
Aye.
First Vice Chair Shanley.
Yes.
Second Vice Chair McEntee.
Yes.
Edwards. Yes. Representative Casimiro.
Yes.
Representative Millet.
No.
Representative Bella Wilkinson.
No.
Representative Corvese.
No.
Representative Almeida.
Yes.
Representative Canario.
Yes.
Representative McKiernan.
Yes.
Representative Jackson.
Yes.
Representative Norrie.
No.
Representative Place.
No.
Representative Roberts.
No.
And Minority Leader Bolivia.
No.
Nine to 70.
Thank you. Do you want to take a 5-minute break to, a bunch of people here that aren't interested in the rest of our agenda, so.